Patton.
He's not listening to his attorney. That's what the problem is.
The statute.
The 25-year minimum, which probably caused a dispute, which why he wants you removed, because a new attorney is going to come in and tell him it's not that. You've got to be kidding me.
Sir. Michael Gaddy, Assistant Public Defender for Mr. Patton, Your Honor.
Your name, sir?
Andre Patton.
What are we doing?
What did you state your name? Okay. Your Honor, I have
hours ago
discussed this matter with the prosecutor and with Mr. Patton. We'd like to set this matter for a preliminary.
Oops, is next one.
Your Honor, the people have offered not to habitualize this matter. What's commonly referred to as the super habitual. If you were to waive, see.
Discovery is complete.
To the best of my knowledge, sir.
Do I have their witnesses available the 14th? Preliminary examination will be set July 14, 2026 at
9 a.m.
That just messed you up, didn't it? At 9 a.m. before Judge Garwood.
Just see a moment. Can I speak?
Attention, sir.
At this moment, I would like to get something on the record. I would like to remove Mr. Gaddy as my legal representation.
Okay, why?
Information I could have used earlier. Yeah, it's
why do you want to do that?
I don't feel he has my best interest at heart.
Seriously? You're saying Mr. Gaddy has a client that he doesn't have their best interest at heart?
Mr. Gaddy.
For that, Mr. Gaddy, how long have you been practicing?
a little bit, Judge.
A little bit, like 25 plus years?
Yes, Judge.
And you're going to tell, and he's been practicing before me for that long, and I've never seen a point in time ever that he didn't have his client's best interest at heart until today.
Mr. Gaddy has been very argumentative with me in certain instances.
Maybe he's told you what you need to hear, but you're not listening?
No, he has done that.
Okay, that's his job.
I understand that, sir.
So are you going to hire your own attorney?
No, sir.
Well, you got the PD's office. That's it.
Sir.
And the PD then has assigned Mr. Gaddy to represent the case. So if you want to do something different, I'm going to undo this setting of preliminary examination, and I'll just adjourn it out for you to decide what you want to do.
I'd like to move forward to prelim.
You would like to move, and you understand that Mr. Gaddy will be your attorney maybe on that prelim.
Okay.
Well, okay, what?
Move forward. I have to move forward to preliminary hearing.
So you're withdrawing your request to have Mr. Gaddy removed?
I am, sir.
Probably a smart move.
At this point, Judge Simpson is trying to figure out whether Patton really has a problem with his lawyer or simply does not like the legal advice he is receiving. A defendant with a public defender usually cannot get a new lawyer just because the attorney is blunt, argues with them, or recommends a strategy they do not like. The court normally looks for something more serious, such as a conflict of interest, a complete breakdown in communication, or poor legal representation. Patton does not give the judge a clear example of Gaddy acting against his interests. Judge Simpson also points out that Gaddy has more than 25 years of experience and a strong professional record. That does not automatically mean everything between them is working perfectly, but it explains why the judge takes Patton's request seriously. Then Judge Simpson asks an important question. Will Patton hire a private lawyer? Patton says no. If Gaddy were removed, it could delay the scheduled preliminary examination without fixing the real disagreement. Patton eventually withdraws his request and agrees to continue with Gaddy. The question is whether Patton truly changed his mind or simply realized that getting a new lawyer was not automatic. The bigger issue is what legal advice caused the disagreement and whether Patton fully understands what could happen if he rejects that advice.
Yes.
I apologize, Your Honor. I was going to say that the offer was not going to be kept open. For example, it was kept open until this hearing, and at this point, it will not be kept open.
It will not be kept open so he can get the habitual.
25 years. Right.
You understand that? And you still want to go forward with prelim?
Your Honor, I don't know if Mr. Patton...
He's not listening to his attorney. That's what the problem is.
Yeah, I don't know if Mr. Patton would consider, in the court would consider adjourning this 1 week, and the prosecutor consider keeping that open so that he can. I have advised him of this. I've explained the the statute.
The $25-year minimum, which probably caused a dispute, which why he wants you removed, because a new attorney is going to come in and tell him it's not that. You've got to be kidding me.
I don't know if Mr. Patton and Your Honor would consider it appropriate maybe to adjourn this 1 week so I can make sure that he is. I'm very sure he's fully aware. I just want to make sure that given the events of today, that he is completely aware and there's absolutely no confusion or question about it. But that would be up to him, Ms. Zenda, and Your Honor.
I would have no objection.
What do you want to do?
I want a better understanding of what's going on.
So you want me to adjourn it so you can talk to Mr. Gaddy and listen to what he has to say? You may not like what comes out of his mouth, but you...
Not that, sir.
Pardon?
Not that. It's not that I don't like what's going on. It's not that I don't like what he's saying. That
What do you want me to do? You want to go ahead with your preliminary examination or you want an adjournment? Those are your choices.
I'm going to waive my prelim. I don't want to do that.
Nobody's asking you to waive your prelim. You want your prelim or you want an adjournment at which time decide after that adjournment that you want a prelim, it'll be set for a prelim. Those are your choices. Pick one.
Understanding, sir, what they were telling me was if I adjourn my preliminary, it will move the habitual. That's what was explained to me. Is that not correct?
No, Your Honor. I've explained that the people have offered, and again, I've explained that the people have offered not to habitualize this matter and such in the way stated with the mandatory 25 should there be a waiver, and that the people would withdraw that offer once an exam is set. I don't think we had adjourned this last week or last time for this eventuality, and we did discuss the matter. So, to the extent that there may be some confusion, I think perhaps adjourning this a week would.
Is that what you want to do, sir?
Yeah, we can adjourn it, sir.
Where is it? Just mark it. You want 1 week or two, Mr. Gaddy, for him to understand what's going on?
Yeah, I can. I believe 1 week will be ample.
During July 9th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Yeah, just so everyone's aware, Ms. Zenda will leave that offer open until next week.
Because she's a lot nicer than I would be.
Now the real reason for the disagreement becomes clear. The prosecution has offered not to seek a more serious habitual offender penalty that could carry a stated mandatory 25-year minimum. But there is a condition. Patton must give up his right to a preliminary examination, and the offer could be withdrawn if the examination is scheduled. A preliminary examination can be important because it requires the prosecution to show enough evidence to move the case forward. It also gives the defense an early chance to see more of the evidence. But in this case, asking for that hearing could cost Patton an important plea offer. That is why Gaddy asks for 1 week. He wants Patton to fully understand the choice before making a decision that could have serious consequences. Judge Simpson does not try to argue through every disagreement in court. Instead, he gives Patton more time. The judge moves the hearing to July 9th, keeps the bond in place, and confirms that the prosecutor will keep the offer available until then. Do you think 1 week is enough time to understand a decision with consequences this serious? The judge's comments toward the attorney may have sounded sharp, but his actual decision was cautious. Patton was not forced to give up the preliminary examination, and the plea option was temporarily protected.
Gaddy, apparently you don't know what you're talking about.
Good morning, Your Honor. And you received a PH 7447 on behalf of Defendant Sarah McCormick.
We're trying to.
Right, yeah.
Good morning, Your
thank
Honor.
you.
Sarah McCormick.
Thank you. All right, what are we doing?
Judge, the prosecutor has offered me a deal to drop this down to a misdemeanor substance use. I have recommended this to my client. I've been trying to get in contact with her, but I've been having a hard time at Huron Valley. I reached out to 3 different people: her sister, her boyfriend, and a friend, to get her the message. I don't know if she's received the message and she's ready to accept the plea here. If you don't mind me asking my client, because we're ready to move forward. Sarah, have you received my messages? I've been trying to contact you.
My communications.
I have. This is completely unorthodox. I just spoke with Mr. I had a 6-hour parole board meeting regarding the suspension of my release pending the outcome of this case. I didn't know yet until yesterday what the matter was.
Yes. Ma'am, I'm going to stop you because this is not something everybody should be hearing. Okay. I hear you. I get it.
Sorry.
But no, it's not your fault. Really, it's not yours. Counsel, you're going to need to get in touch with your client, have that private conversation, then make a decision as to what they want to do without everybody else like you're being involved. So
I'm ready to move forward, though.
Pardon?
I'm ready to enter a plea. I'm trying to agree to this.
We're pleading guilty to the amended charge.
I don't have the paperwork.
Okay.
So I can't do anything, or I'm not going to do anything.
Thank you, Judge. I'll have the paperwork complete with the prosecutor. We'll get it over to you, and then we'll move forward to the next hearing.
When's that going to be? I was supposed to leave last week, and my husband's terminally. He's on the kidney registration list. Like, I'm his caretaker. I was supposed to leave 11 months ago. This is holding me up. The parole board said, PR bond or not. Mr. Sito, I'm completely blown away. Like, I have a right to move forward with this. My civil liberty is being
Sarah, stop.
Ma'am, the quickest I can get you in, because we have to do a video writ, would be the 16th. I will set it as quick as possible. We'll get it. They'll get the paperwork to me, and I'll be more than happy to take your plea.
Thank you, sir. Thank you so much.
You're welcome. July 16th, 2026, 9 a.m.
Thank you, Judge.
Thank you. Thank you.
Thank you.
These hearings show one important lesson. Moving quickly is not always the best option when a defendant does not fully understand a major legal decision. In Patton's case, Judge Simpson did not remove his appointed lawyer or force him to give up the preliminary examination. Instead, the judge gave him 1 week until July 9th, kept his bond in place, and confirmed that the prosecutor would keep the non-enhancement offer open until then. This gave Patton time to understand his options before making a decision that could not easily be undone. The possible 25-year minimum made it even more important that Patton understood exactly what he was choosing. In McCormick's case, there was no accepted plea. The judge stopped the sensitive discussion in open court, told the attorney to finish the required paperwork, and scheduled the earliest available video plea date for July 16th. Her family situation and concerns about being released explain why she wanted things handled quickly. But those concerns do not allow the court to skip important legal steps. Do you think Judge Simpson made the right decision by slowing things down and protecting the legal process? The bigger lesson is simple. Disagreeing with a lawyer is not automatically the same as having bad representation. Not understanding legal advice is also different from having a serious breakdown between a lawyer and client. Judges have to make sure defendants understand important decisions before allowing them to make choices that could seriously affect their future. In these hearings, the delay was not a punishment. It gave both defendants more time to understand their options and helped prevent decisions from being made without proper understanding. If you found this case shocking, make sure to like the video, share your opinion in the comments, and subscribe for more courtroom breakdowns.